Then they amend this act. In January, the Assembly passes this act, which has introduces a new section called Section 17(2). And in this Section 17(2), the government gives itself the power to change the zone in the regional plan on an application filed by the plot owner. So they make it very simple. Means you file a simple application. If your field is if your plot is in a paddy field, it is on a slope, it is in a natural cover area with forest or whatever, you file a simple application with the government saying that you have put my land in the wrong zone. It should be in settlement zone. So please change it to settlement. And this very wise government of ours says, yes, what you are saying is correct. Your paddy field or your forest is wrongly shown as forest and paddy field. We will change it to settlement. You pay this much fees. So fees have been fixed. You pay the fees and you get your zone changed. So technically, entire state of Goa can today file application for change of zone. So there is no regional plan anymore, and there is no Town and Country Planning Act, because Town and Country Planning Act is based on regional plan, because everything has to be done as per the regional plan, as per Section 9. But now anybody and everybody can file an application. Now you will say, what is wrong with this? Then there is no more planning in the state, because anybody can put any project in any place by just telling the government, make an application, my zone is incorrect, and therefore please change it to the correct zone. What is the correct zone? It is usually settlement. Now, I have given, the petition gives, this is from the petition. You look at the last page at the bottom, this gives the actual analysis of the plots that have been changed in 24 cases by Mr. Vishwajit Rane and the Town Planning Department. 24 cases from April till June. Last notification has come somewhere on 22nd of June. And we are showing that all the changes are from paddy fields to settlement, natural cover to settlement, orchard to settlement. Out of 100%, all these three zones have been converted on the ground that they are wrong zones. Now, if a forest is a forest, how can you say it is a wrong zone? And if there is a field, and it is a paddy field as per the Form 1 and 14, how do you say it is a wrong zone? And if it is a hill slope and the Town Planning Department has marked it as an NDZ, how do you say it is a wrong zone and that it should be made into a settlement zone? So this is the absurdity of what they are doing, which means now the Vishwajit Rane in a Facebook post has said there are 6 crore square meters like this which have to be changed, which have been wrongly shown in the regional plan. They are wrongly shown as forest area, as orchard area, as paddy field or whatever it is. And it is my duty to do a service to the people of Goa and to get all these zones changed. The 6 crore square meters of land is going to be converted between now and the next elections, for you know what the purpose is, between now and the next elections, so that nothing remains of the state of Goa after this exercise. Nothing remains. Imagine what is 6 crore square meters. What is done so far is 80,000, 83,000 and 18,000. That is something like 1,70,000. We have to reach 6 crore. And all these 6 crore, according to the minister, are basically the ecologically sensitive areas of forest slopes and paddy fields, and most likely also khazans and mangroves. So this is the project that is under 17(2). It is worse than 16B, because in 16B at least, though we are opposed to it, at least there was a committee, there was a Town and Country Planning Board, it had to come in the Gazette, you could file objections to it, you could show that it is a forest zone so you cannot convert, and all those corrections were at least technically possible, though we don't think that it can be done at all, because if planning is done by every individual saying that my plot should be a settlement and you have put it in in agriculture, or you have put it here, or you have put it there, but I am saying that it should be in settlement area, then what is the basis of planning? After that, there is no purpose of any planning exercise. They can scrap the town planning department, scrap the town planning minister also, because it's not required. Right now, with 16B, you have to go to the town and country planning board, you have to get it gazetted, you have to listen to objections. In 17.2, nothing is there. Only the chief town planner and the minister decide. So, only two people now are responsible for the destruction of the state. Previously, at least you could have said there was many more people, but now only two people are taking on the responsibility for total destruction of the state, and that is the town planning minister and the chief town planner. Now, town planning minister comes and goes, but why the chief town planner should commit harakiri is beyond our comprehension. Because if the chief town planner himself says that no planning is required, that all the work done by the task force in 2008, they made mistakes of 6 crore square meters. This is what they are saying. They are saying that the previous expert body was so useless and so incompetent that they miszoned 6 crore square meters. Is it the position that the government can take today? The government is a continuous body. Today's government cannot say the earlier government has marked 6 crore square meters as erroneously as wrong zone. Today's government has to take the responsibility for the wrong zoning if there were zoning. According to us, all the plots in these 24 notifications which we have challenged in the High Court, all the plots were correctly zoned and not one of them is in error. All of them are correctly zoned. Now, why it is being done, we have given in the press note. Look at the values of these zones as they are being changed. The plots where the zones are being changed. In Anjuna, one of the plots is sold for 74 lakhs in December. After conversion and zone change, in June it is sold for 6.8 crores. 74 lakhs to 6.8 crores. Another plot is changed in Asagaon, and the value of the sale deed is 60 crores. 60 crores. You please understand what is happening in the state of Goa. Who is buying this land? Whether any Goankar can buy this land at these particular rates, but the whole land speculation business has now become a complete menace to Goa and its ecology. And this has to stop. We have put all this in the petition. We have put these facts, these tables, these figures, everything we have put in the petition. And the court yesterday has issued notice for our matter to be taken up on the 24th. And they have told them you file replies, and we will see how much further this can be done. But we just want to warn the Goa public that in the next 1 year, this is what is going to happen. Anybody who wants this plot to change will approach either the minister or the chief town planner, make a simple application, pay the fees and get his zone changed. One question we have raised in the petition is very simply this. If the government has made an error in describing some plot as no development slope or natural cover, and today the government says that is an error and we want to change it to settlement, why is the party being made to pay? Very simple question. You make the error, you pay for it. All over in all economic transactions, if somebody makes the error, he pays for it. So if the government has made error in 6 crore, why is the government is collecting money from all these people for making the change? That is the admission that there is something wrong. Because somebody wants to change the zone and therefore is willing to pay the money. Every Goan is not in a position to pay the money. 90% of the Goankars will not be in a position to pay the money for the charges. So only those who can afford to pay. Secondly, we have said, all these plots, regional plan is in force from 2012. All these plots are purchased in the last 1 year. So, When you purchased the plot, you knew that it was orchard zone, you knew that it was no development slope, you knew that the paddy, you knew when you purchased the plot. But you purchased it for 77 lakhs. Today you get the zone change and you get the value put up to 6.8 crores. So this is the game. This is the game that is being operated. You knew that a mistake, you should not have collected any money. You know that it is not a mistake because you have purchased the plot of land in the last 1 year. If last 1 year, how can you blame regional plan made an error in 2012? You should have said in 2012, the original owner should have said in 2012, "Arey Baba, you have put in the regional plan, you have put my plot in the wrong zone. No, you please put it in the correct zone. Otherwise, I'll go to the High Court and get it changed, or I will go to some other place and get it changed." But you don't do that. You wait for 10 years. And in 2023, you make an application saying, "Na, Mosa zone sarkona, mashi change." Is it possible for anybody to believe? But this is what is happening under 72. And that is why we believe that all the environmental organizations are wholly opposed to this. We will challenge this. Now we have challenged 24 cases. All the 24 parties are made parties in our petition. And we are watching the Gazette, because every week the Gazette is coming out with new cases. Those new people are being made parties in the new petition. And they are going with such speed that in the beginning, in the first Gazette, which was that, what is that, Reddy? Yeah. Ganga Reddy, they put the plan of the plot and the name of the party in the Gazette. But after that, they have forgotten to put the name of the person also and the plan of the person also. Now it is becoming like very quick, because they don't have time to do anything. So they are putting in the Gazette only the plot number and what is supposed to be changed. The name of the party, more than out of 24, more than half the names are not in the Gazette notification at all. So the court has directed the Town and Country Planning Department to give the petitioners the names of the parties. Why are they hiding? And we are making them parties also in the petition. So everything is being done in a manner which lacks complete transparency. When we asked under RTI, for access to the files of this Ganga Reddy and all these proposals, we have been informed that our RTI application cannot be entertained because there is a circular from the government that all RTI applications for town planning have to go to the minister, and only after the minister approves can they release the information. Now this is not in the RTI Act at all. So we have filed an appeal immediately. But the purpose is to delay release of the information. One day the information is bound to come. But purpose is to delay for 2 months, 3 months, 4 months, till the party gets their permissions from the panchayat or from the town planning or whatever it is. All that will be done with very great speed so that they are entitled to start the construction. But not a single file is being released to the press. If what the government is doing is proper, legal and defendable, let them put a scanned copy of all the files on the net. Let them disclose all the names of the parties who are making these applications. And let them disclose the names of all the other people who are involved. If the government is very clear that this is a transparent process. As of today, it is not, because all information is being denied. Madam, you want to add something?
Yes. What is happening is the rights of the people are being violated all along. Making of the regional plan is a participatory process. As per the 73rd and 74th Amendment of the Constitution, the plans have to be made at the local body level and then it is finalized. Now, this regional plan was made by a participatory process, but now when the amendment comes in, that 17(2) amendment comes in, there is no participatory process of the people. People have no say in the plan. So if the village has sent up a plan and there is some change which is happening, the people of the village will not know. This is done in the quiet, and whenever any plans are made, it has to be looked as a whole, not as small pieces of plots which are changed into zone. And as we have and the second point that I wanted to make is the TCP Minister, Mr. Vishwajit Rane, has made a statement that he does not want to have a regional plan. That is totally wrong. It violates the rights of the people. Okay, you cannot say you will not have the regional plan. It is part of our act, it is part of the constitution, and all the MLAs have taken a vow and sworn on the constitution. And now how can you say that you're not going to follow the constitution? The third thing what I want to say is, today when we are talking about planning of Goa, it is not in the interest of people of Goa. You can see it is to make money. Whether it is money taken from the people who want change in zone, or there are lots of people wanting to convert their land, and that is happening at a lots of people come and tell us that in the office we have been asked so much of money. So there is money which is openly, as per the law, they made a law that they are going to charge the money, and there is money which is being taken which is not under the purview of the law. Okay, so money is the criteria for planning. Now what happens in such a scenario? All the plots and zones get changed, all the eco-sensitive zones get destroyed. So when the hills get cut, water table in the hill, which the hill protects the water table, that goes. If our mangroves are destroyed, the salinity comes in. If our fields go, we don't have food security. So this will lead to the destruction of Goa. Secondly, we know climate change is happening. We are having, now encroachment on river beds also. There flood-like situations can happen. And when there is an environmental disaster, it is the people of Goa who will have to bear the consequences. All these moneyed people will just leave Goa and they'll go to greener pastures. All of them will move where, because they have the money to buy their plane ticket and own houses elsewhere, and they will move. This whole zone change is for the builder lobby. All these people are moneyed people. They have no interest of Goa at all, and people of Goa are being exploited, and we have to oppose this, and the people of Goa should rise to protect their state. They have been doing in the past, and once again we will be out on the streets right now. The petition is in the court, so whatever battle has to be fought at the court level, that will be fought. Whatever battle has to be fought with the legislators who are making this legislation, that will be done by the people of Goa.
I'm saying that we cannot compromise our ecological assets, number one. Number two, we cannot compromise on our democratic rights as citizens of Goa, which means that I should have a right not just to know what is happening, but also a right in the decision of planning. And the third thing is that Goa should be affordable for the Goans, for them to be able to build and also have their homes, and also continue in the state. These are my 3 points.
Any questions?
So, 17.2 was brought saying that it is brought to make corrections as per 2001 plan.
Yeah.
Have you checked
2011, 2021.
The scrutiny committee.
2001 plan. Earlier it was settlement, then in 2021 it was converted to natural cover orchard. So those corrections. So have you checked with old plans like 2021? This same basis?
See, we are going strictly by 2021 changes. All the changes that are done now are not of 2001, they are of 2021.
They're saying that
It may
21
be-
is faulty, so that's why we are coming out with correction.
Yeah, but see, if 2001 was faulty, you had a high-powered committee in 2000, we spent 2 years and the plans were sent to all the panchayats. If you take even Pada Panchayat, where I come from, we got the regional plan for Pada 2020, whatever it's called 2021. It came there in 2008. They had several Gram Sabhas. We saw that what was done was largely correct. Whatever we wanted corrected, we also suggested should be corrected. But I don't see what further errors were there, because that the collective inspection of the plans by the village people, that was done. So village people are very smart. They know if something is shown wrongly, they would immediately indicate what is. Now, for example, if you look at ODPs of Para, ODPs of Para, Kalangut, Kandoli, Arpura, Nagaon, there are 5 villages which are put into ODP. All of them have got tenanted lands which have been shown as settlement. In the regional plan, they are shown as agriculture. But in the ODP, they are shown as settlement. But village people know. So all of them are asking how these settlement areas, how these agricultural tenanted fields are showing as settlement. Because they know that this field is a tenanted field, that is a tenanted field. They know, because you are relying on the collective wisdom of the village population to correct. So 2021 was corrected to a large extent by the people in the village, and the scale was also different. If you look at 2001, the scale was 1:50,000. That is why you require certificates and all from town planning. But in the case of 2021, everything is available on the internet. Every sector, every taluka plan of RP 2021 is there from the year 2010, when it was notified by Digambar Kamath in a series of taluka maps, and then it came into force. So, if you have to correct, you could have corrected at that stage. You could have written to the government in 2012 saying that, look, this is wrong.
They again notified in 2016.
No, see, that is a trick the government played, with the Padikar played, which I don't want to go into. In 2012, he suspended.
Kept in abeyance.
He kept in abeyance, but there is no provision to keep in abeyance. It came up in the High Court. The government admitted that they had not notified the order. It was a plain circular. Now, by a circular, you cannot put in abeyance a regional plan. And they passed an order to restore it in 2018, March 2018. Both those orders are totally illegal orders. They are issued as circulars, but they have no effect of law. Legally, the regional plan was in force from 2012 till 2020. There has been no change. There has been absolutely no change.
So we have followed the same regional plan?
Yes, which was notified in 2012.
Even for the errors, there was supposed to be a scrutiny committee. And even without the scrutiny committee scrutinizing this, they have notified these changes.
Yeah, they have set up a scrutiny committee on 25th of May. But before 25th of May, in the month of April itself, about 12-13 approvals have been granted. All these, whatever, Ganga Reddy ones have been granted without the approval of scrutinizing committee. So the scrutinizing committee is not supposed to scrutinize individual proposals. They are supposed to scrutinize RP 2021 and then say to the government, look, these are the errors which we think should be considered by the government. Then the government can proceed with changing it. The scrutinizing committee is not doing that. Scrutinizing committee is saying, here is the application for change. Here is an application for change. And you please tell us whether it is okay or not. Of course, scrutinizing committee is not containing any independent person there. I think it has got that Mr. Paresh Gaitu there on it. I don't know whether he is there also.
So what happens to those?
He is on the scrutinizing committee.
He's on TCP board.
He is on TCP board. He is the main dalal in the entire Goa planning scene.
So what happens to those resolutions which were taken in panchayats and all? You know, there was this saying that the Gram Sabhas will take resolutions on this RP issue.
The Gram Sabha took resolution. Pada Gram Sabha took a resolution. I was present. That we will accept only the regional plan which we have drawn and not the one sent to us by town planning department. But Mr. Digambar Kamath rejected all those changes. He did not accept anything. It reverted back the town planning department reclaimed the plans and whatever the task force had decided. Not only that, they had a special committee after that called the SLC. The SLC made even more changes. They put even more changes like these micro industrial estates, eco zones, all those were put by the SLC after the regional plan was approved and sent to all the villages. So, land is a very priceless commodity. You can imagine all these games. In no other state, in Delhi and all that, they have a master plan, they stick to the master plan. It is not possible for you to do any changes. It's very strict. Only in Goa, every year the plan is being changed, the zones are being colored, what is green becomes brown, it comes in the gazette, it doesn't come in the gazette because it only involves money. It's only big money. As I said, where is the sale deed in Goa which is ending up at 60 crores? This is one of the 24. 60 crores. Which Goenkar can get land at 60 crores? But this is what is facing the state. And I am ashamed to say that the town and country planning minister is trying to defend the whole exercise as an exercise where some poor people have got their zone wrongly zoned in RP 21, but these are not poor people. Where the land value is 6.8 crores and 20 crores, these are not poor people. And all the 24 people are not poor, not one poor man is there, all these are real estate developers. So the game is very clear.
So Minister claimed that RP 2021 was a scam from Goa.
So let them say, see, it is his own government. As we said, government is a continuing factor. Mr. Vijay Rani can't come to the High Court and say it was the earlier government. It is the same government. Was it not the same chief town planner? The same town and country planning department which prepared RP 2021. The same people are in charge right now. Nobody has changed. At the most their successes have come. It's not that a new town and country planning department has been set up and they have found everything wrong. It's the same department, same officers. So he cannot take the point of view that the earlier government did a lot of errors and so on. He should have done it as soon as he became town planning minister. He has not done it. He has waited for 1 year. Now he is interested in becoming the chief minister, so he needs money.
And if there are errors, the regional plan can be revised. You go by the law. So we have already, like 2021 is over, start the process for the new one.
If you no objection.
Yeah, go as per the law and participatory process.
He said there will be no regional plan henceforth.
Yes, which is totally wrong.
That is wrong because under section 9 and according to the rules framed for implementation of 17.2, they have got to take into consideration the regional plan. That's the rules which are framed.
That amendment zone plan.
Zoning is a different matter. The zoning for taking the plan to the zone, to the what they call district levels or taluka levels or what, that's a different issue. They have amended. They have amended the law to say that we will have zoning plan. But if you look at the zoning plan amendment which is passed by the legislature, it acknowledges very clearly that the zoning plan will take into consideration the regional plan. That's in the law. People don't read the law, but if you read the zoning plan amendment of 2022, it very clearly says that the zoning plans will be based on regional plan. Because you cannot have any plan without regional plan. Mr. Vishnu Rani has become town planning minister only for 1 year, no? So he has to study. We are here from 1986 when we have been looking at the town. Regional plan is fundamental to the Town and Country Planning Act. Well, you cannot go without a regional plan. Minister may say what he wants. Minister always says what he wants, then they correct it afterwards. To say something, when the media asks them some question or something, they say something.
Thank you for coming.